The Supreme Court just took the biggest gun case in years. The biggest Second Amendment case in decades is officially happening. The Supreme Court has just agreed to decide whether states can ban the most popular rifle in America, the AR-15. Now, this isn't just another gun case. The court is about to answer one question that could affect millions of gun owners across the country. If the justices rule one way, assault weapon bans in over a dozen states could be wiped off the books. And if they rule the other way, those bans could become much harder to challenge. Today, we're going to be breaking down exactly what happened, why this case matters, what each side is arguing, and what this could mean for the future of the Second Amendment. So let's get into it. Welcome back to the 2A Defense Network. If you are new here, this channel covers the biggest Second Amendment news without the political spin. So if that is something that you are interested in, make sure to subscribe and turn on notifications because this case is going to dominate gun rights news for weeks to come. Now let's talk about what the Supreme Court actually did. On Tuesday, the Supreme Court announced it is officially taking two major Second Amendment cases, and those cases are Viramontes versus Cook County and Grant versus Higgins. Rather than hear them separately, the court consolidated them into one case because both essentially ask the same question. Can the government ban AR-15s and similar semi-automatic rifles? Now the court framed the question like this: do the Second and 14th Amendments guarantee Americans the right to possess AR-15 platform and similar semi-automatic rifles? That is now the question the highest court in the country will answer, and whatever the answer is will likely become the law for every state in America. Now, both cases challenge assault weapons bans. One comes from Cook County, Illinois, the other comes from Connecticut. Now, gun rights organizations challenged both laws, arguing they violate the Second Amendment. However, both federal appeals courts upheld the bans. Now, the Seventh Circuit ruled Illinois' ban could remain in place, and the Second Circuit reached the same conclusion for Connecticut. After losing in those courts, gun rights groups appealed directly to the Supreme Court, and now the justices have agreed to hear the case. This is something that many legal experts and gun owners have been waiting for years to come. So why is this such a big deal? To understand why this matters, you have to go back to the Supreme Court's 2022 decision in the Bruen case. In Bruen, the court dramatically changed how gun laws must be evaluated. Instead of using balancing tests about public safety, courts now have to ask one primary question: is the restriction consistent with America's historical tradition of firearms regulation? Since Bruen was decided, lawsuits challenging assault weapons bans have exploded across the country, and gun rights advocates have made overturning these bans one of their highest priorities. Meanwhile, several blue states actually expanded assault weapon bans after Bruen. In fact, 5 states enacted new bans in just the few years following that decision, and the legal battle has only intensified. Now, this announcement didn't come completely out of nowhere. Last year, the Supreme Court declined to hear a challenge involving Maryland's assault weapon ban. But Justice Brett Kavanaugh wrote something that is very important. He said more appeals courts' decisions would help the Supreme Court, and he predicted the court would likely take an AR-15 case within the next term or two. Well, that's exactly what just happened. The court has now decided it's finally time to answer that question. Now, gun rights groups celebrate the announcement. This is huge news. Adam Kraut, the executive director of the Second Amendment Foundation, said the rifles are among the most commonly owned firearms in America. Because they're so common, he argues they clearly fall within the protections of the Second Amendment. That argument traces back to the Supreme Court's Heller decision in 2008. In Heller, the court ruled that firearms in common use for lawful purposes receive constitutional protection. Supporters of these lawsuits argue that the AR-15 is now America's most popular rifle and therefore fits squarely within that standard. Gun control organizations, well, as you can guess, strongly disagree. Everytown Law argues assault weapons are uniquely dangerous and are frequently used in high-profile mass shootings. They say that these laws are critical public safety measures and remain fully consistent with the Constitution. And those competing arguments are now headed directly to the Supreme Court. So what could happen? Right now, 12 states and the District of Columbia have assault weapons bans in some form. And if the Supreme Court strikes these laws down, those bans could become unconstitutional nationwide. If the court upholds the bans, states may receive even stronger legal authority to continue enforcing them or adopt new ones. And this decision won't just affect Illinois or Connecticut. It could reshape firearms laws across the entire United States. The court also made another important decision this week. it chose not to hear several other Second Amendment cases. That includes challenges to magazine capacity bans, including California's long-running Duncan versus Bonta case. And many legal experts believe the court is waiting to resolve the AR-15 issue before deciding those magazine cases. Now, the justices also declined to hear several other cases involving firearms rights for adults between the ages of 18 and 20. And federal appeals courts remain split on those questions, meaning that legal battle is far from over. Oral arguments are expected this fall, and a final decision could come anytime before June of 2027. Now, whatever happens, this will almost certainly become one of the most significant Second Amendment rulings since Heller, and possibly since Bruin. This is a case that every single gun owner in America, every state government, and every constitutional law expert will be watching very closely. So what do you think the Supreme Court will decide? Should AR-15s receive the same constitutional protection as handguns under Heller, or should states be allowed to ban them altogether? I want to know what you think down in the comment section below. And if you found this breakdown helpful, do not forget to hit that like button, subscribe to the 2A Defense Network, and turn on notifications, because I will be covering every development in this case from oral arguments all the way to the final decision. Thank you for watching, and as always, I will see you in the next one.